Yes, Mr. McLean. Why don't you assume you've said enough on the first point as to whether there was a contract, and now tell us what you say the terms of the contract were.
Yes. As far as the terms of the contract, my lord, those terms are the terms which the learned judge identified as being incorporated into the contract in paragraph 68 of his judgment. He said in paragraph 68, the contract between the parties and the obligations of RTS and Müller Müller submits to be found in the following documents, namely the documents attached to the email, the URS, the KPIs, the assumptions for free issue equipment, the documents attached to Mr. Pierre's second emails, etc., etc. The learned judge went on to hold in paragraph 77 that by no later than the 29th of June to provide the goods and services and comply with the obligations specified set out in the documents referred to in paragraph 68. So those are the terms which this contract contained. In our submission, the learned judge was correct to conclude that those were the terms. Now, as far as the liquidated damages are concerned, your lordships will have seen in paragraph 74 of the learned judge's judgment. This is the Schedule 6 point, which your lordships are aware of. That he said that although many of the schedules were agreed, several were not, and he's identified, I think, earlier in his judgment under paragraph 51 the extent to which there was disagreement about the schedules. Your lordships see that, for example, paragraph 12, Schedule 12, this related to certificates of payment never completed, health and safety requirements never completed, etc., etc. But the important point in paragraph 74 is the words where he says it wasn't agreed what Schedule 6 would contain. The words in capitals set out in paragraph 48 above represented a prose but never agreed refinement to give Müller some ampler remedy than liquidated damages if the performance of the equipment was lower than that of the degree of non-performance which would give rise to the maximum liquidated damages. So the effect of the learned judge's determination in our submission is that even if this court were to take the view that the reasons the learned judge gave for the exclusion of the MF1 terms was wrong, and that your lordships saw your way to including within the contract the MF1 terms, one thing is clear in my submission. What can't be included as part of the contract are the terms relating to liquidated damages, because, as is clear from the learned judge's judgment, there was an unresolved dispute about the extent to which Müller was entitled to a more ample remedy in relation to that. And that dispute.
I'm not absolutely sure that I have absolutely clearly in my own mind just exactly what these terms were. They come in originally, is this right? Or they're referred to originally in the letter of intent.
Yes. Now,
they're described as Müller's amended form, MF1 contract, and so on.
Yeah. It might help if your lordship...
And where do we find those?
Yes. Your lordship finds those in bundle appendix part 2, 1 of 2, at tab 41. It's a bundle which says on the front, appendix part 2, 1 of 2. As your lordship see on page 771, you have a front piece. It's dated blank, and it's between Molkerei Alois Müller, RTS Advanced Robotics, and RTS PLC. Does your lordship see that?
Yes.
These are the MF1 conditions, which follow at Schedule 1 on page 774. And this is the fourth draft of these terms which was in evidence at trial. And if your lordship turns on, you'll see the clause 48 is on page 785. The parent company guarantees addressed in paragraph 48A.
So these were terms which were originally being proposed on your side, is that right, in the letter of intent? They were a riposte to the RTS terms.
Well, I think that's a reasonable way of summarising it. What happened was that RTS said at the outset that it was happy to contract on its standard terms and conditions or on some modified version of these MF1 terms. Now, the original MF1 terms which were put forward by Müller contained a whole number of amendments to these standard terms, which were based on a model form issued by the Institute of Electrical and Mechanical Engineers. This fourth draft represents the ultimate draft before things went quiet in relation to it. Schedule 6, which is the schedule which the learned judge referred to in his judgment at paragraph 74, is found on page 796 of the bundle. 795 and 796. And Schedule 6 is dealing with performance tests. Your lordships will see on page 796 wording in uppercase, which says this schedule needs to provide that if the test is within a certain percentage of the required level, LDs, that's liquidated damages, will apply and the equipment will still have been passed. If the percentage achieved is lower than that specified by LDs, i.e. lower than the maximum payout under LDs, the equipment will have failed the test and the other remedies will be available to the purchaser. So, as the learned judge said in his judgment at paragraph 54, the words in capitals represented a proposed but never agreed refinement to give Müller some more ample remedy than liquidated damages. Now, what my learned friend says in his alternative case in relation to this is that your lordships should conclude, if you conclude there was a contract, that Müller's remedy is restricted to £42,000. And he says that's what the parties agreed. But it's perfectly obvious from Schedule 6 and from what the learned and the findings of the learned judge that the parties did not agree that £42,000 should be the extent of Müller's remedy in the event that the equipment did not satisfy the performance test which the parties had agreed.
And where does the 42,000 come from?
The 42,000 is based on 2.5% of the contract price. And that, your lordship sees on page 773 of this document. Under the heading performance tests, maximum percentage of contract price for which liquidated damages payments under clause 27.71 is 2.5%. And you'll see above that, percentage of contract price to be paid to the purchaser, deduct from contract price to be calculated in accordance with Schedule 6. Now, 2.5% of 1.682 million is about £42,000. But the point which I'm making to your lordships is, and which the learned judge found as a fact, the parties were not agreed on the extent of the remedy in the event that the performance tests were not carried out satisfactorily. It was not agreed that £42,000 should be the extent of the liability of RTS to Müller. And that one finds from paragraph 74 of the learned judge's judgment. And when one looks at Schedule 6, which contains the words in uppercase which were not agreed. So, we say that the learned judge was right to conclude that the contract terms included the documents he identified in paragraph 68.
So, I was just going to ask so just looking at the actual documents, there was no dispute about the terms of the MF terms themselves, is that right?
That's correct.
And the sole issue then is the bits in uppercase, is it in Schedule 6?
That's right, that's
in
correct.
This context.
That's correct. That's correct.
Just going back to paragraph 67 and 68 of the judge's judgment.
Yes, my lord.
A contract was always defined as the contract and the schedules.
Yes, it was.
And you say that the schedules mentioned in 68, which most of the documents, I think, in paragraph 68 are schedules to
Yes,
the
they are.
contract.
Yes, they are.
You say that they are terms of the contract because they were signed. And you distinguish, that's what the judge's reasoning is anyway.
Well, yes, the signature was an expression of agreement in relation to those. In relation to those schedules.
Well, that's why I'm puzzled by that, because the distinction the judge seems to draw between the document in 67 and 68
Yes.
is the absence of a signature in relation to the contract, whereas he finds the schedules part of the contract because they were signed.
No, the schedules weren't signed. I'm telling you. No.
Well, in written documents.
Well, they were in agreed form. Some of them were in agreed form.
But
And that's clear from.
It's the emails. There are two emails, my Lord, principally. I take your Lordship to in due course. 67 records, well, we're slightly baffled at the moment because it was my learned friend's case that there was no contract because it required formal execution, which he's now saying is a new case that we ran in the Court of Appeal. And his case proved too much. That was the problem in the Court of Appeal for him. So the starting point was that was their case. What the judge relied on was that the part of the contract schedules, which your Lordship rightly identifies, included the matters relied on by my learned friend as forming the contract. They were sent through as agreed contract schedules under two emails identified by the judge. And for some reason, my learned friend's case is, those schedules alone are taken out of everything else that was agreed, but not signed, and they form a contract that we entered into. That's the thrust of the debate between us before the Lordship.
So then what is the distinction between the agreed schedule, what you say is the schedules which were agreed, and the contract which was not agreed?
When you say the contract, you mean the MF1 terms?
Yes, the
Is that
MF1
right?
terms. Yes.
Yes, well, the distinction is.
Because the MF1 terms are the contract.
Well, the MF1 terms and the schedules are the terms of the MF1 definition of the contract. That's right.
But the essential contract terms are in the, I mean, obviously they include the schedules as well, but otherwise they're the terms in the MF1 provisions, are they?
Yes, they are.
Yeah.
And they
Now,
were agreed apart
well,
from
those were agreed
Schedule 6.
apart from this liquidated damages point, which the judge regarded as significant and important when it came to considering whether the MF1 terms were agreed.
So then why do you say the schedules are contractual terms?
Why do I say the schedules were contractual terms? Because the schedules represented, obviously represented what the parties agreed this equipment, what this equipment should be capable of achieving. It set out all the performance criteria, what it was that was being supplied. And if you're asking, well, what is it that was being supplied, you look at the schedules and you see what's being supplied. Because the schedules set out in great detail the technical requirements of the repackaging lines. There's a test plan, there's a user requirement specification, there is provision about site acceptance tests, all the things which one would need to know in order to know what it was that was being supplied.
Could you give us the reference to the two emails?
Yes.
These are the ones referred to in paragraph 68, little 1 and little 2.
Page 51 and 52.
Thank you.
Perhaps they're not. No.
It's 48, my Lord, tab 48, which is referred to by the judge, and your Lordship will see our understanding of the current status of the contract schedules is as follows, and then the bits that my learned friend has picked out
Sorry, you're reading from where?
Page 830, my lord. It's an email from Mr. Brown of RTS to Mr. William Morris.
So it's 48 and 52.
48 and 51 are the two emails which contain the documents my learned friend says form part of the contract.
And at tab 52 as well, there's an email of the 29th of June.
That's also.
What's the inference from the 48? Because
From
in relation to Schedule 6, the judge recites that the email of the 16th of May introduced this refinement, which was not agreed.
yes,
But then the next email, 26th of May, simply says RTS test plan for Schedule 6.
well,
Does that mean that the refinement remains or disappears?
the refinement doesn't disappear. It's a matter which, as the judge says, was never resolved. It was not agreed. And that's what he's saying in paragraph 74 of his judgment. So this proposed refinement came out on the 16th of May, and it continued to remain a point which was not agreed between the parties thereafter. And my submission is that as a result of that proposed refinement, the liquidated damages provisions necessarily were not agreed, because it is clear that Müller was holding out for a more refined, a more ample remedy than would otherwise have been provided simply by the liquidated damages. And that's the conclusion the learned judge reached, and the learned judge was right about that.
How does it fit with the emails of the 5th of July, where your clients were saying that everything had been tied up? That's tab 54 and 56.
Yes. Well, it's subject to this point. The
Which it doesn't say so. He says,
Schedule 6 point.
he says,
That's the conclusion the learned judge reached on the evidence matter.
but does the judge deal with the 5th of July
He
emails?
does. I think so.
He mentions them somewhere, but I'm not sure he mentions them in paragraph 67.
Yes. Which one? Paragraph 50 as well, my lord. That relates to the force majeure clause, which was agreed in July. But as far as the Schedule 6 point is concerned, the judge's conclusion, having heard the evidence, was that that had not been agreed. And, I mean, I don't recollect whether there was any cross-examination of the witnesses, which is relevant to this particular issue. I'm reminded by my learned friend, Mr. Feely, in fact, there was cross-examination of Mr. Morris in relation to Schedule 6. I can't tell you precisely what it was that Mr. Morris said. Mr. Morris was the representative of Müller.
Well, what about paragraph? You see, this is what struck me as curious, because paragraph 51, the judge recites the email of the 26th of May, which is tab 48, and then in relation to Schedule 5 and 6, we've now got RTS test plan, and then the comment the judge makes is RTS regarded its test plan as covering the grounds of Schedules 5 and 6, and Müller was happy with that, provided it did so. But the only version of Schedule 6 contained Müller's wording. That rather suggests that the written wording that you've been referring to from the 16th of May is actually disappearing out of sight and being replaced by the RTS test plan.
Yes, well, that's not the conclusion the judge reached.
No, but you said there was examination of Müller's witness, and where's the finding Müller was happy with that? Where does that come from?
That presumably is from the correspondence and from the witness evidence.
Well, if that's right, doesn't it amount to a finding that they'd forgotten about the capitals now, and they were replacing the whole of Schedules 5 and 6 with the RTS test plan?
No, my lord, it doesn't.
Well, do we see the test plan?
Do we see the test plan? Yeah, that's Schedule 6.
It's page 1044, isn't
Yes.
it, in the bundle in tab 51.
That's the FDS and test plan. Yes, your lordship's right. That is the test plan. That's the agreed test plan. At that point, but as I said, the judge's conclusion on the evidence was that Müller was seeking for a more adequate remedy in relation to the predicted damages, which was never agreed. And his conclusion was not that somehow it fell between the cracks, but rather the parties had not agreed that provision.
But that's inconsistent, really, with your client's legal advisor's view, isn't it, on the 5th of July, which is that everything was now ready for signature?
Well, that in my submission is reading too much into what is said in that email, and one has to take into consideration what the evidence was at trial in relation to this, which led the judge to the conclusion that this more ample remedy was not in fact agreed.
Have we got the evidence, the references somewhere to it?
Yes, you've got, well, there's Appendix Part 2, additional 5th bundle.
Additional what, sorry?
It says Appendix Part 2, my lord, additional 5th bundle. Tab 86, at pages 34 to 36. And the lordship sees that Mr. Manzoni at line 6 has been cross-examining Mr. Morris, and Mr. Justice Christopher Clark asks him some questions starting at line 20.
So, which page is that, please?
Sorry, my lord, it's page 34, line 20. One goes over the page to 35, you see the learned judge ask some questions of Mr. Morris.
The marked differences at line 21, which are the ones proffered in March 2005? That's edition 4, is it?
I think it's an earlier draft, my lord. It can't be 4, because that comes later than March 2005.
No, but the ones, when were they?
16th of May was the last version. I've taken your lordship to the wrong bit. It's a
I help.
bit below at paragraph 24.
The additions were 15th of March was the first version, 2005. Then there was a revised version, 14th of April, another revision on the 11th of May, and another revision on the 16th of May. So your lordships have seen the one on the 16th of May.
And that's the fourth version?
That's the fourth.
And the final version?
Yes.
Or the final complete
That's the
version?
last one that's sent through between the parties.
That's right. You'll see at page 35, line 4, Mr. Justice Christopher Clark asks about the capital letters on Schedule 6.
Is this the first reference there was to them in the case?
No, I don't think so.
It looks as if the witness was asked about them because at line 5,
Well, one goes back to page 29 of the bundle. One is into the cross-examination of Mr. Morris and Mr. Manzoni, by Mr. Manzoni. In line 9, he says, he's talking about Schedule 6. This Schedule 6 in its revised form was drafted by Mr. Salisbury, was it? You see that, my lords? Yes. And he's going through the various drafts. And on page 30, Mr. Morris says he thinks there were some elements that were still outstanding.
so sorry, just before I go on, the words in capital letters,
Yes.
were they added to one of the drafts, or do they appear? Which draft were they?
Third draft.
The third draft. They were first in the third draft, were they?
My junior problem.
Yes. 11th of May, my lord.
11th of May. Third draft.
Right.
So they came in at tab 39 of the appendix, part 2, 1 of 2. Tab 39. 748. It first came in. So see at paragraph, page 31, line 4, Mr. Manzoni, I think, is asking Mr. Morris about his witness statement. And he says, I think you identified those in your paragraph 35, you identified 3 outstanding issues. And then the second outstanding issue is exactly as you've just identified, the way in which the liquidated damages provision is integrated with the passing of the performance testing. So, afraid in the bundles before your lordship you don't have the witness statements, but as far as the evidence shows in our submission, it is right that this Schedule 6 point was an outstanding issue, and the judge was correct in our submission to identify it as such. With the result that it is plain and obvious that there was an unresolved dispute as to the extent to which liquidated damages could apply in relation to the performance of this equipment.
Well, the dispute is putting it a bit high. There wasn't any commentary about this schedule, and this witness, what he says about it, is rather strange. The judge asked him what it was you were seeking to achieve. As I recall, it wasn't all clear the way in which the performance test and the result of running that test would then have I presume on the liquidated damage provisions applying to it. And this was my suggestion, I think, actually probably to my own team, although I acknowledge it is in a document that was externally, as to how I imagined that would work.
Well, the fact
I mean,
is
it was
that
pretty inchoate. There wasn't any suggestion as to what provisions were to
No, but
cut in.
that's why that issue was not yet resolved.
Or pursued.
Well, if you're right, your lordship's right. It wasn't pursued. Of course, your lordship's right. But the question that if you're considering whether the MF1 terms were included, the question obviously you've got to consider is whether objectively, in relation to all of those terms, the parties are to be taken to have agreed them. And in the light of the judge's finding, in my submission, it's simply not open to the court to conclude that the liquidated damages provision was agreed in consequence of the fact that Schedule 6, having been proposed, was never actually dealt with. So you can't, in my submission, reach the conclusion that liquidated damages of £42,000 apply when it's obvious in my submission, as the judge found, that Müller was interested in some more ample remedy. Now, it's true that things went quiet thereafter, but it doesn't follow from things going quiet thereafter and the parties performing the transaction that the conclusion one reaches is that they were happy with the liquidated damages provisions. On the contrary, the objective conclusion one reaches is they had not reached agreement on the liquidated damages provisions by reason of the Schedule 6 point.
Appears to be very limited. It's a bit difficult to get the flavour without the witness statement, but there appears to be very limited evidence about this, and there doesn't appear to have been any questioning about what he thought he was doing, Mr. Morris, on the 5th of July.
Yeah, well, one of the problems is that when my learned friend Mr. Manzoni cross-examined the witnesses, he cross-examined them with a view to establishing that not all of these schedules were agreed. That not all of the schedules were agreed, and the judge remarked on this in closing when Mr. Manzoni said that the MF1 terms were agreed. And the judge said, but I thought you cross-examined with a view to establishing that these things were not agreed.
Indeed, at page 32, he seems to have been saying it wouldn't be accurate, would it, that you were pushing for signature? And the irony we have, it's been, your witness was saying, oh yes, we were pushing for signature. It was more or less all agreed.
Yes, well,
There's a certain irony in all that.
There is a certain irony in all of that, my lord, yes. But taking, as your lordship says, the degree of irony, one does not, in my submission, come to the conclusion, contrary to the finding of fact by the learned judge, that the liquidated damages provisions were in fact agreed.
Where do we see my Lord Mance asked you about the entry in the little box the judge has in paragraph 51, where he says RTS regarded its test ban as covering the ground of Schedules 5 and 6. Müller was happy with that, provided that it did so. Well, now, we haven't quite seen the evidence about that, have we?
No, we haven't.
In fact, at all, not about...
Fine. I regret I am not clear.
So the judge must have had some basis for that.
He must have had some basis for that, yes.
Because that seems to suggest that the test plan would essentially cover the problem.
Well,
Now, whether that's right or wrong, I don't know, because the test plan's quite a long document. It seems to be quite a technical document.
There are three emails of the 5th of July. Taken together, they start at 11:06. I mean, if you read all three together, it looks like there's a done deal.
Mr. Brown's your man. No, Mr. Brown is...
no, Mr. Brown is
RTS.
I'm sitting with Mick to put together the final contract.
Yes.
There's force majeure, which was an outstanding point. Next
Yes.
one, that seems fine.
Yes.
Final one, thanks for getting back to me. I'll incorporate it into a contract when I put all the schedules together, and we should be in a position to be signed and forwarded for signature this week.
Yes. Certainly. Well, as your lordship can see, I'm obviously having difficulty in putting my fingers precisely on what it is that led the judge to...
Well, you said it appears to have been agreed to be a done deal, but it wasn't in reality.
In reality, it wasn't, by reason of this Schedule 6 point. And it's certainly not... Well, I'm not in a position to give you chapter and verse on the evidence, because, frankly, I've not been looking at that. Perhaps I shouldn't. But as far as the judge was concerned, he made the finding of fact that he did on paragraph 74. And I don't think it's been suggested that there wasn't any evidence on which he could come to that conclusion.
Speaking for myself, it does seem to me that it would be of some assistance perhaps to look at the relevant bits of the witness statement and the relevant bit of the evidence which gave rise to what the judge said in
Tab
page
85, tab 85, page 141. It's in the cross-examination of Mr. St John of Müller.
85?
Tab 85, page 141 of the transcript. Starting from about line 18. Page 141.
Page?
Page 141, my lord. Perhaps, since my learned friends make it, so it's from line 18 and then over the page.
Who's being cross-examined here?
Mr. St John, who is the project manager for Müller.
So,
irony. We come back to the irony.
so there you see. So, Mr.
This is
Manzoni.
RTS saying, putting to the witness,
Yes.
there wasn't any agreement.
Okay.
Bringing the reluctant concession, you're probably right.
So, the judge, as I've said, came to the conclusion that he did in paragraph 74. His conclusion of fact was not challenged in the Court of Appeal, and I don't believe in this court that they're saying that that was wrong. So, if the judge was right, as we say, your lordships must take him to be, in finding that there was some ampler remedy which Müller was seeking for, it was unresolved, and the consequence of that is, as far as MF1 is concerned, either that none of the MF1 terms can be taken to be agreed, or that certainly the liquidated damages provisions of the MF1 cannot be taken to have been agreed.
And which are they?
Liquidated damages is clause 27
2.5%.
of the MF1, which you find page 732. Sorry, 780. Yes,
Clause
27 in the performance test. And in particular, it starts to kick in. This point starts to kick in at paragraph 27.7 if the works fail to pass the performance test, as determined by the provisions of Schedule 6, then the following remedies will be available. It then goes on to set out the liquidated damages remedies, for which, as the judge found, Müller wanted an ampler remedy. So, whatever conclusion your lordship reach, if you reach the conclusion that there was a contract and it contained some or all of these terms, the conclusion your lordships cannot reach in my submission is one which involves the proposition that these liquidated damages provisions were agreed, because, as the judge says, a more ampler remedy was up for grabs. And if that's right, none of the liquidated damages remedies can apply.
What? Help me as to when Mr. Who is it being examined in tab 85? Mr. Brown. When Mr. No, it's not. It's somebody else. Page 1.
Mr. St. John.
Oh, when is it that Mr. St. John is supposed to have handed a document to Mr. Gavin Brown in July? I'm just looking at page 142.
Yes, I know, my lord. One looks at paragraph 122 of the judgment. It doesn't answer your lordship's question, but it does at least identify the handing over the document.
122.
Yes.
Yes. I noticed, in fact, that Mr. Manzoni, at page 155 in the next tab, did run alternative cases. He said, there still remains the wording drafted by Mr. Salisbury in Schedule 6. Your Lordship can either take the view there was no agreement to that and therefore no Schedule 6, or alternatively, your Lordship might take the view that the suggestion by RTS wasn't assented to. The test plan was subsequently agreed, and so our Schedule 6 should be the test plan.
Yes, but that doesn't address the issues as to the more ample remedy.
Well, I think what he's saying is that the test plan, RTS test plan, becomes Schedule 6.
Yes, but what the judge did in his judgment is make a finding of fact that Müller was still seeking an ampler remedy, and the conclusion that one draws from that, if one is going down the route of saying, well, what terms were incorporated into this contract, is that one can't conclude that the liquidated damages, as set out in the draft, were included in the absence of agreement on the more ampler remedy. So,
what actually happened? Testing went by the board anyway because they varied the bringing on stream line 1 and line 2.
Factory test, customer acceptance testing didn't take place.
Yeah.
And as your lordship has seen from the judgment, that gave rise to an argument by RTS that as that had not been undertaken, the site acceptance test provisions had gone by the board, and we had no comeback against RTS. As long as, if it actually, when it was put into operation, didn't work. But SAC testing did not go by the board, and your lordship has seen Mr. Brown's acceptance recorded in the judge's judgment that Müller was still entitled to expect SAC testing, and that it would in due course be carried out. Now, the judge left open for further determination as a result of a dispute on the facts, whether that had been waived or not. But as far as the stage we got to at the trial, the judge did not conclude that SAC testing had gone by the board. That simply wasn't open to him on the facts. And indeed, the conclusion or the evidence which Mr. Brown gave was that we were still entitled to expect it. Yes, and in accordance with the judge's findings in relation to what were the terms, he found that we were entitled to SAT tests. That's recorded at page 32 of the bundle. In the judge's order, where you see on page 32 of the bundle under issue 1.2.3, the question is SAT testing by the claimant mandatory, and on the proper construction of the relevant contractual provisions, what are the necessary elements of the defendant taking over the equipment? And the judge answered that by saying, unless dispensed with by Müller, SAT testing was mandatory for RTS. Takeover under the contract was to occur once the SAT tests had been successfully completed at Müller's premises. So that was the conclusion the judge reached on the issues, and it's supported by what he says at paragraphs 102 and 103 of his judgment, which you'll find on page 68 of the bundle. And this is derived from the test plan, which the judge concluded was an agreed document. So, yeah, and in the final point that I made,
and where the answer says on page 7, unless dispensed with by Müller, is there any issue about whether Müller dispensed with it?
yes, there is.
So that's a issue for some future trial.
It is. Yes. Because it was suggested as a result of conversations which took place in, I think, in November or December, that somehow Müller had dispensed with those. But that wasn't an issue which the judge felt able to resolve on the state of the evidence before him at the trial. Now, it's right that I should repeat the point which I've already made in relation to these terms and conditions. That, as one sees, from page 771 and 772, this was intended to be a tripartite contract, and the parent company guarantee, which was envisaged, was never given. So that is another aspect of these terms and conditions, which was not...
Well, that would lead to no contract, would it?
Well, it wouldn't lead to no contract, no.
Why not? Be the logic of it.
No, it wouldn't lead logically to the conclusion there was no contract. Logically lead to the conclusion that RTS plc hadn't given a guarantee. But it doesn't follow from... That leads to the conclusion that these MF1 terms were not agreed, not with no contract. And as I've said, when one is examining what, if any, of these terms might otherwise be applicable to a contract, one has to take the judge's determination or finding in paragraph 74 of his judgment that there was a more ample remedy, which is simply Müller agreed. Now that is what I propose to say about the terms of the contract. Yes. But I haven't amplified what I said at the beginning in relation to clause 48. I will do so if your lordships wish me to do so. But
I don't think we do at the moment. You don't want to hear that, do you? No.
May I then finish simply by making a number of points about whether it was right for the Court of Appeal to allow the points which were taken below to be taken, and make that point relatively quickly. I invite your lordships to be guided by the summary of the principles that Lady Justice Arden set out in the case of Crane and Sky Television, which you find at tab 9 of volume 1, in terms of whether the court permits a change of case on appeal. And the learned Lady Justice in that case summarised the principles. It starts at page up. It's, for some reason, it's numbered 131 at the bottom of the page. Paragraph 18 of the judgment conclusions, where she deals with part 52, and she sets out what Justice May had said in the case of Jones and MBNA. Normally, each party should bring before the court the whole relevant case he wishes to advance, and may choose to confine his claim or defence to some only of the theoretical ways in which the case may be put. But paragraph 19, she cites from the speech of Lord Herschel in the Tasmania, where he says that a court of appeal ought only to decide in favour of an appellant on a ground there put forward for the first time if it be satisfied beyond doubt, first, that it has before it all the facts bearing upon the new contention, completely as would have been if the controversy had arisen at trial. The learned Lady Justice says at paragraph 20, Lord Herschel, dealing with the situation where the party seeks to raise a new case by asserting the accident happened in a different way from that which suggests at trial. The passage stresses the importance of ensuring that the other party is not put at risk of prejudice. And then she cites from the judgment of Lord Justice Peter Gibson. But it's really at page 134, I want to refer you, Lordships. She says there's further useful guidance in this passage. For the purpose of the present case, Lord Justice Peter Gibson adopted the approach that before allowing a new case to be raised on appeal, he had to be satisfied if a new case had been raised at trial, the other party would not have altered the way it conducted the case. Likewise, in this case, in my judgment, the court has to be satisfied that SAH will not be at risk of prejudice if a new point is allowed, because it might have adduced other evidence at trial or otherwise conducted the case differently. It should consider for itself as best it can what factual issues are likely to be raised with a new case. Moreover, in circumstances such as the present, where there has been no disclosure relative to the new way in which the appellant seeks to put his case and virtually no opportunity to consider the matter, I do not consider that the court can reasonably expect the party against whom the amendment is sought to be made to be specific about the evidence he would have adduced if the point had been raised earlier. If there's any area of doubt, the benefit of it must be given to the party against whom the amendment is sought. Yet it is the party who should have raised the point at trial who should bear any risk of prejudice. And the point applies, my lords, not only the point applies in relation to issues of law. Even in relation to an issue of law, the Court of Appeal has to be satisfied that it would not have affected the way in which the other party would have conducted its case at trial. We might not have adduced further evidence to deal with it. So, in the present case, we have in our submission, as the Court of Appeal recognised in paragraphs 47 and 48 of its judgment, a new positive case of no contract, advanced at least at the Court of Appeal stage on the propositions that essential terms not agreed, on the basis of that clause 48 was a complete answer. As far as the essential terms argument is concerned, perhaps the force of the point is somewhat reduced by the observations of my Lord Mance that the Court of Appeal don't appear to have decided it on the basis of essential terms. But that isn't an answer to the point. If the essential terms argument is an argument of fact, which I submit it is, then it should not have been allowed for the first time in the Court of Appeal because it is a matter which properly should have been investigated at trial, and that it was not. So The Court of Appeal were wrong to allow the essential terms argument in the Court of Appeal. In my submission, for similar reasons, they are wrong to allow the argument which treated Clause 48 effectively as a subject contract clause, because that could have been addressed in evidence. And we've set out in our case, paragraphs 114 through to 129, the relevant issues of fact which we say bear upon this particular point. I'm not going to labour the point at this stage in the afternoon, but we do say that the Court of Appeal is wrong to allow these points to be taken. So, my Lords, we would invite the Supreme Court to overturn the decision of the Court of Appeal that there was no contract, and to restore the decision of the learned judge, Justice Clark. And if there's anything else I can say at this stage to assist you, Lordships, I will. Otherwise, I shall sit down.
Thank you.
And perhaps, I mean, just in one sentence, it may be going over ground, but why do we light upon the particular documents and not others?
We light upon the particular documents because the learned judge has concluded that those are the documents which were agreed and not others.
But, I mean, he's... you mean any document which you can find which the parties have, so to speak, said we needn't look at that document anymore?
No, it's not quite as simple as that, for the reasons that I've tried to explain in relation to the liquidated damages point. Liquidated damages point is the Schedule 6, which impinges on the question whether those liquidated damages provisions are agreed at all.
Quite. No, I mean, I see that. That's what I meant.
Yeah,
if you find something that isn't agreed, what, you strike out the whole document?
Well, that's my primary submission, but my alternative submission would be that you only strike out that part which plainly clause Schedule 6 impacts.
Which happens to be just the clause you'd like to strike out.
Well, one of them.
Yes.
One of them.
Yes.
Does doing that, Schedule 6, does that involve striking out the whole of the MF terms?
Well,
is Schedule 6, do the MF terms appear elsewhere other than in Schedule 6?
I think it's the other way around. Schedule 6 reflects on the MF1 terms.
Yes.
I think it's the other way around with respect.
I think you would like to have in the actual provisions for testing and so on.
Well, those appear in the schedules.
Yes, yes.
Which the judge found were part of the contract.
Yes.
And that's where the obligations the judge found arise from.
Are they schedules to some other part of the contract? Or are they schedules to the MF provisions?
Schedules.
No, they're schedules to the two-page document.
That's right. The schedules to the two-page
to which the MF conditions
MF1 is
are
Schedule 1. That's right.
Yes.
That's right. MF1.
Now, just remind me where the one clause you'd like to get rid of through the mechanism of Schedule 6 is the maximum percentage of contract price for which liquidated damages payments are paid is 2.5%. Is that the one?
That's right.
It's clause 27, or 27.7.
27.7 and following. Because, as I say, I made my submissions on why the court, whatever it does, can't conclude that those are agreed terms.
Yes, thank you. Mr. Feely. Yes, Mr. Catchpot.
My Lord, I don't know whether your Lordship is reminded to grant the shorthand right for 5 minutes, or whether...
Yes, Lordship, in 5 minutes.
refer to, I will place them on the end of their various benches, and if it's referred to, so they know where they are.
All rise.
May it please your lordships, your lordships now have an additional bundle, which is a little black bundle, and the sheet of paper I can explain briefly. They are simply the extracts from the evidence that your lordships have before you, which relate to, on both sides, what the parties said in their evidence about the MF1 terms. And the short point is, it was common ground and remains common ground. Everyone expected to contract on a contract that incorporated the MF1 terms. It was the effect of my learned friend's submissions and the judge's findings that led to the conclusion which we have challenged, that somehow a contract was formed that did not incorporate those terms which have been in effect agreed by the time the judge held his contract had been concluded. The more substantial document is a copy, almost, of a document already in the bundles. It's at tab 75 of your Lordship's bundles. Yes. This was something that Mr. Manzoni very carefully drafted for the purposes of the Court of Appeal, so it's a constructed document, but the purpose of it was to show how the amendments to the different forms developed and the times at which they developed. The reason why we've done it again is because, unfortunately, in the colour photocopying, the colours changed, and what was orange, which was our comment, became virtually illegible. So the change that we've made to the one before the Court of Appeal is we've now, if your Lordships look on the first page, the bottom entry says dark red, comment on the agreed, not agreed status, and that was our comment, which was orange in the previous version. I will come back to that in a moment, because I hope your Lordships will find it helpful to see essentially why we're complaining, that the judge came to the conclusion that he did, and I'll come back to it very shortly. But may I start with some preliminary observations? Your Lordships are concerned here with a case, the primary case, which was actually advanced by my learned friends at trial. The problem for them was that their case proved too much. It was their case that, and I'll show your Lordship expressly in the oral arguments and in their pleadings, their case that the agreements between the parties were in effect a subject to contract agreement. And they relied on the extent of the negotiations, and your Lordship's already seen in paragraph 67 of the Court of Appeals, of Mr. Justice Clark's judgment, that they accurately record my learned friend's submission as being, in effect, it was a subject to contract case. The problem for that was, of course, when they woke up to the fact that contract, as defined in the various terms, was a defined term, as we pointed out to the Court of Appeal. And that meant that if they were right, and the judge was right in his conclusions, then the only logical conclusion was that there was no contract between the parties. And that was effectively the primary case that we ran in the Court of Appeal. It was to say, if the judge is right, take everything he says, when you correct his misunderstanding of what the word contract in Clause 48 meant, put it all together, whichever basis of the four you choose, you lead to the same conclusion, namely no contract. So we challenged the inference that he drew from his own findings of fact. If that goes, somehow, if it's not a subject to contract type case, then our case was at trial and remains in the alternative, well, one looks to see what the parties had actually agreed. What the parties had actually agreed was a contract including various schedules and specifically including the MF1 terms that they'd settled by that stage. What you can't have in our submission is what my learned friend has managed to persuade Mr. Justice Clark to achieve, which is you take out certain bits of a composite contract that you like, you argue that the rest somehow is not enforceable because it's subject to contract, but then you say simply because you performed there must be a contract, and therefore it must be on the bits that we like. And that's essentially what it comes down to. And again, by way of opening remarks, could I stress a note of caution about my learned friend's submissions on performance? The judge found, paragraph 77 of his judgment, reflecting the case advanced by my learned friend, that at the latest, by the 29th of June 2005, a contract was concluded. So any performance with which your Lordships are concerned, any conduct that led to the conclusion of that contract, by a matter of logic, predates the 29th of June 2005. So references to my learned friend about, well, it's been very interesting to have a debate about variations and things like that, simply don't enter into the debate at all, because the case they advanced, the case that the judge found, was that was the cut-off date. And there was either some kind of offer and acceptance at that point, or the conduct was such that the parties had reached a concluded agreement on the basis of the terms that he alleges. And the difficulty with that, again by way of introduction, was flagged up by, I think it was my Lord Collins, who identified that if one goes in part 2 of the appendices to tab 56, bearing in mind the 29th of June date,
54 to 56.
Yeah, 56, my lord, is the one that contains all three of the emails, just a convenient way of dealing with all three. 6 days after the contract my learned friend was concluded, 6 days after 29th of June, there is an exchange of emails, which starts with Mr. Morris, the legal advisor to Müller, at the bottom of the page, picking up on the one point that was outstanding, as I will show your lordship, on the MF1 terms, namely the definition of force majeure.
Sorry, which page is that?
It's page 1110, my lord.
Yeah.
Bottom of the page. Gavin, I'm sitting with Mick, that's the project manager, Mr. Mick St. John of Müller, in the next few days to put together the final contract for signing. So the starting point is, at this stage, they are still contemplating, first of all of these schedules will be put into a contract and that it will be signed. Yet the judge has found by this stage that this person, who has negotiated on behalf of Müller, had actually entered into an agreement with RTS on a completely different basis 6 days earlier.
And the force majeure point below, what's that?
Force majeure, there'd been I'll show your lordship in a moment, but there'd been a discussion between the parties.
Actually, this is in a very, very small print.
Yes, exactly.
Sorry.
And it's just a revised definition. On the same day, the response comes from Mr. Gavin Brown of RTS, that seems fine. And Mr. Morris then says, thanks for getting back to me. I'll incorporate into a contract when I put all schedules together with Mick. Now, all schedules are the very documents your lordships have seen, including the schedules that my friend says form the basis of the contract between ourselves and the parties, but only some of them. So between ourselves and his clients. The agreement should be in a position to be signed and forwarded to you for signature this week. And I'll come back to the learned judge's reasoning, but your lordships will recall that there were 4 different reasons given. The first was that it was in effect a subject contract relationship, that the parties always proceeded on the basis the contract would be one that would only become effective, irrespective of clause 48, when it was signed. That's exactly what is happening 6 days after the date on which he found a contract to exist. And the short point was, if that's right, then it applies to all of the parts of the contract, not just some of them. The second point, which I do actually, in my respectful submission, tie up with the same point, is that the contract was always seen by the parties as a composite whole, and it was. Your lordships will see in due course that every time they refer to the schedules, they refer to them as contract schedules. So if there is, for some reason, as the judge found, some schedule isn't agreed, and that precludes an agreement, then it precludes an agreement on the whole, unless at some later stage there was an agreement which no one's alleged or pleaded, and I'll show you why, because it was their positive case there was no change in the party status, that somewhere down the line the parties agreed something different. That isn't before your lordships. The third one I'll come back to in a moment. The fourth ground was clause 48, and that's exactly what they're talking about here. Clause 48 was saying until you sign, there is going to be no effective agreement between the parties. And the concept that we struggled with was how you could have, apparently, conduct in the period that the parties are actually negotiating and agreeing terms, where they have agreed a whole raft of terms, and somehow the judge has concluded, urged by my learned friend, that what has been agreed is not the entirety of what had been agreed at the time, just little bits of it which are favourable to his clients. And in my submission, there's no principle of law that leads to that conclusion. It's certainly not Percy Trentham, nor is it actually a matter of common sense that that could be the result. So if one applies even a general standard of what reasonable, honest businessmen would have expected, the one thing they wouldn't have expected was for anything to be other than what had been agreed and was expected to be signed in a few days, as at the 5th of July, and that means the MF1 terms. So it doesn't matter which way, from my client's perspective, it goes. Either there is no contract because the judge is right, or if the judge's reasoning goes and somehow there was no bar on them having reached agreement because they didn't need formal execution, then it's a matter, as your lordships have said, of looking what was actually agreed, which is the MF1 terms. Whatever it is, it's not what the judge or my learned friend would have you believe.
The date of the 29th of June isn't written in concrete. It's the document you refer to in your case at paragraph 5 as the document where the Müller put forward their case shows that they in fact put forward a variety of alternatives, end of May, end of June, or on or about 5th September.
Is absolutely right. And because of the nature of the submissions that have been advanced, if your lordships will permit me, I will take your lordships to the way the argument was put. But by the time the matter got to trial, my learned friend put this case on the basis that at the latest, 29th of June, a contract had been formed.
But the really forceful basis for saying that there must be a contract here is things which happened after the 29th of June, it seems to me. I mean, you've got a strong point. The 5th of July, they were contemplating putting something in writing, but 5th of July, they appear, on one view, to have agreed everything or almost everything. But what happened after that is that they actually then discussed a variation of the basic scheme because of the Tesco order, and they actually performed by paying and making delivery. And it's those factors which, if you look at Lord Justice Staines' approach, could be quite compelling.
But that wasn't what was run at trial. And I'll show you. My lord, the question would then be, for my learned friend to get home, there would have to be some unequivocal acceptance of an offer or something else which showed that my clients had moved away from a position where they were expecting to contract on the MF1 terms, and Müller had moved away from that position.
Well, I think no one is necessarily suggesting that. If one's asking whether there was a contractual intention, though, there certainly was something unequivocal. Performance is a very unequivocal act.
Yes, although one does have to be, I agree with your lordship, and if I may say so, one of the problems which I apprehend the Court of Appeal was picking up on in this case was that, certainly in my reading, and it's a matter for your lordships, Lord Justice Staines was not saying in Trentham, this is an absolute rule, every time there's been performance, there must be a contract. That would be an absurd conclusion to come to. What he was saying, quite rightly, was that where there has been performance, then it may be much more difficult to argue that the parties haven't actually entered into a contract.
I actually thought this perfectly obviously a contract here. The work was carried out in accordance with a whole lot of detailed provisions, and it was carried out for an agreed price. And I don't see how that leads to anything other than the contract. Well, the terms of the contract, I don't know, but the idea that there isn't a contract seems to me to be very, very far-fetched indeed.
Well, my lord, I'll come back to the idea that there is no contract comes in effect because there was no meeting. Our case was, and I'll show your lordships, no meeting of minds if on the basis of what my learned friend suggests. Their case has always been 29th of June principally, the date on which we are supposed to have agreed a contract with specific schedules ignoring the MF1 terms. Now, if that is what is put against us, there is no contract. If what is put to me is, did my clients expect and believe that they had contracted on the basis of the MF1 terms, the answer is yes, which is why they performed.
The case that you read in the Court of Appeal was really prompted by what the judge had found.
It follows exactly what you were saying. We accepted, we were bound by what the judge found, but the problem was he'd accepted a case which just proved too much as far as they were concerned. But that is absolutely the case they ran, and I will show your lordship's provision. Their case was, and is, that this was a subject contract case, and if that's right, then it is a subject contract case. And that means no contract. And that is their conclusion from their own argument. And all the nonsense about it being a new case really has just been a smokescreen. Because bizarre, and there has been a very bizarre case. Parties have changed sides, your lordships may have detected in the bundle.
Well, whether it's a new case or not, I just thought it was perfectly obviously a contract.
Yeah, but your lordship detected that this very argument I am now advancing in front of your lordships was put by Mr. Brown in negotiations in November and December of 2005.
But what drives one to the conclusion that there was a contract is really what happened after the 5th of July. And I can see that if on the 6th of July one of the parties had suddenly said, Müller said, suddenly we noticed that your parent actually hasn't signed the guarantee, that's it, I'm terribly sorry. Then there might have been quite a strong case for saying the parties had been proceeding on the basis until there was a signature, there was nothing binding. But then, I mean, what seems to be the position is that they were all ready to sign. It wasn't that anybody had any objection to any of the terms. They just overlooked it, and nobody noticed for about 5 or 6 months that the signature wasn't there. They just went on as though it had been signed. Isn't that really the picture?
My lord, perhaps your lordship is absolutely right. Yes. I think the phrase was used, I think it was Mr. Brown who was cross-examined to say they just were content to let sleeping dogs lie. But it was Müller who were going to put a version of the contract back. a version was handed over in July, but it didn't contain all of the schedules, and then no one really did anything very much. And your lordships will recall that if one lordship goes forward to the judge's conclusions, it's tab 4 of the core bundle, page 72, paragraph 121. This is part way through performance. By this stage, line 1,
Sorry,
paragraph 121 of the judgment, my lord. His lordship, this is line 1 had been delivered out of sequence as my Lord Phillips identified as a result of the variation. And this is a meeting took place in Mr. Morris's office at Market Drayton on the 18th of November to discuss finalisation of the contract. By this stage, the relationship between the parties was beginning to break down. Mr. Brown expressed the view that so much had changed since the last round of contract discussions in May-June, that if the parties signed the contract in the form that had been largely agreed, both parties would find themselves to have been in breach. He indicated to Muller in advance of the meeting that if the contract was going to be signed, there would have to be a side letter which explained what happened since August 2005 and how that affected the parties' obligations. And that, of course, flags up one of the problems with cases where you have performance and accepted by conduct, that generally they only and it becomes an issue once the relationship is broken down. But the advantage of trying to take a look at the snapshot of 29th of June, which is what the case is, rightly or wrongly, is that at that stage, the parties are at an early stage of their contractual performance. And if they've then subsequently breached, then there may be other questions to be addressed about whether there was a agreed variation to it, or waiver of rights. At least gives you a benchmark. But where parties have then gone on and both agree, varied what was in contemplation, it makes it much more difficult to say what is being agreed and what terms are being agreed. The one thing that is consistent on the evidence is that the MF1 terms were the terms that the parties expected to have in their contract. And the one thing the judge has found is that it wasn't. And that is not a conclusion that anyone on the evidence could have come to. I should show your lordships also in...
Where did the judge refer to Mr. Brown saying the parties were content to let sleeping dogs lie? In which paragraph is that?
I will get the reference for you, my lord.
Thank you.
I think it was Muller and Friend. It's not in the... It was in the cross-examination.
It's not in the judgment at all?
No, I believe it was one of my learned friends' cross-examination questions, with his usual eloquence.
Well, it's put rather well in the appellant's skeleton. Apparently, as Mr. Manzoni put it, neither party wanted the contract negotiations to get in the way of the project. The project was the most important thing.
Yes. The question remains, if it's a subject contract case, there was no change to that. And though it may not be, as the Court of Appeal found, very what one would expect in a contract of this type. It's not unusual, sadly, in this particular field to have these sorts of problems. And we've referred to a number of cases in the TCC. It's a familiar problem that I face in my area of practice, where exactly this problem comes up time and time again, very often because parties use the subject contract clause because what they're doing, for understandable reasons, they wait to assemble the whole contract before having a run-through to make sure that when they've got it all together, it having been drafted by engineers here and people there, that it actually makes some sort of coherent sense. And whether they actually achieve that aim is a different matter, even if they sign it. But it's otherwise I wouldn't be in business, one suspects. But tab 65 in Appendix 2, Part 2, again, just like to show you, Lordships, the continuation why it wasn't a case of complete performance before the issues arose. It was a case of part performance, and then arose after the variation. This is a Müller note of a meeting, and note 2 says RTS have incurred additional costs and wish to outline them in due course. Report required on history of project. No formal contract signed must now reflect current situation. Agreement eventually reached in principle, but no bound formal contract issued by Müller. And then, since work commenced, both parties have not followed the terms of the contract. And then 3, quantum merit should apply as only letter of intent, recover costs and reasonable profit. RTS's lawyers would take this route. In fact, what happens is both parties kept taking different points all the way through. And, my lords, before I get to that, can I show your lordships the bundle that I just handed up, which is where the parties were as at 5th of July. And, my lord, we've kept the same page numbering as is in tab 75. Bundle.
Sorry, just before you leave 1124, WM contacted GB 4 weeks ago asking to sign. That's presumably Mr. Morris.
Yes. That's Morris contacted Mr. Brown, and that's the discussion that was reflected in the judge's judgment.
Yes, so he was asking him to sign, presumably, the agreement that had been reached in July.
Yes. And then Mr. Brown was saying, as at November,
That you both
things
be
have
in
moved
breach.
on. And all I was trying to say is that my Lord Phillips is right that if the case was to be, the interesting part would be after the 5th of July, when neither party ran that case, despite what my learned friend pleaded. The September date didn't feature. The reason the 5th of September date is picked is it's the date that the line 1 material was actually delivered to the site, and that triggered a payment obligation, and 2 payments were made which did actually reflect the MF1 terms, 30% and 30%. One was made in April, and one was made on the 8th of September, from memory. So that they had picked a period just incorporating the variation. But the focus was on the 29th of June, and that was the date, certainly, on which the judge made his findings of fact. My Lords, the contents of the MF1 form, I hope the Lordships find this helpful. I certainly did when I asked for it to be prepared. The page 1146, we've simply identified, I'm afraid the references we've kept to the core bundles, but I can give your Lordships the references in your Lordships bundles necessary. What was original wording, when an amendment was introduced. And the purpose of it, in part, was to show that this was a heavily negotiated contract. And it was a short form way of showing that what had happened between January and July was the parties had got together and they had agreed things. And then for some reason, the judge jettisoned what had been agreed and no one was taking points about. And when one gets to the schedules, he picks on some things which are agreed at different points in time, but there's no apparent rationale to it. So one has the different annotations. On 1147, one has the form of contract, and note, it's an important point, paragraph 4, the general terms and conditions set out in Schedule 1 will apply to this contract. So that's there from the start. The 15th of March, the very first time this appears. Schedule 1 is, of course, the MF1 terms. Limitation of liability. Our own friends dealt with part of this story, but not all of it. The only bit that Schedule 6 related to were performance tests, not overall limitations of liability, not delay completion damages. So when my learned friend boldly asserts, well, of course, all liquidated damages go, even if you accept he's wrong, because the parties have already agreed that, and the parties had agreed almost from the outset that the overall cap for performance liquidated damages, whatever they are, would be 2.5%. That is what is in the box at clause 5, 27.7. What Schedule 6 was about was whether there should be some additional remedy available. So once you'd reached that cap, did they have an additional remedy? And I'll come to that in a moment. Then over on page 1148, clause 6, again, original wording, the order of preference of the documents. The document that had the highest priority was Schedule 1, which is the MF1 terms. So that's the document, this form of contract, and the MF1 terms are the documents that the judge jettisons on my learned friend's submissions as not being agreed. Yet from the outset, it's always recognised, 6.1.1, that they would be the dominant conditions of the contract. They govern everything else. And that's why it's a composite whole. The way the contract is structured is to have the nature of the obligations and the remedies set out in the form of contract and the MF1 terms, as one would expect, with then a sort of modular approach dealing with different aspects of the job set out in the schedules. And that's a very common approach in these types of contract. And some of the URS and the FDS were included in my learned friend's contract, and then some of the other schedules were also included, but they come bottom of the pecking order. over the page, 1149, don't intend to take your lordships through these terms and conditions, but broadly your lordships can now see how the parties negotiated and reached agreement on the terms. And what the facts reveal are that they concentrated on doing this first, so that by the 16th of May, the email your lordships have seen, they're saying, are they broadly agreed? To which the answer was yes, no, then we'll concentrate on the other contract schedules. And that's what they then do. They then start filling in the documents my learned friends now rely on, at least some of them. But this then provides what one would expect in a complex contract. This was a contract that wasn't a straightforward supply. This was design, testing at the RTS factory, installation, commissioning, and integration of other equipment provided by third-party contractors into our equipment. Part of that testing was originally due at our premises, part's going to be at theirs. There's going to be access issues because it's a live working environment. So it's exactly the sort of arrangement where one would expect sophisticated parties to want to have conditions governing their contract. And one of the curiosities, if I may just depart from, now I'll come back, your lordships keep that open. Your lordships take the judgment again, which I've now lost. Paragraph 33, paragraph 39 on page 46. This was in the context, this is the learned judge saying why there weren't going to be any terms and conditions in the letter of intent contract. And what he says is, halfway through the, well, this is his reasoning, the absence of agreed full contractual terms, i.e. RTS or MF1, would be of limited significance over a 4-week period, but more significant if it could continue until the end of the project. The parties did not, in my judgment, contemplate that in the absence of finalisation and signature within the specified timescale or any agreed extension, RTS would be bound to continue with a project for which the applicable terms had not been agreed. So it was fine not to have any terms and conditions in the letter of intent contract that was going to last for 4 weeks, but no commercial party in their right mind would enter into a contract of this type without having them in place for full performance. And we agree. And we think that's what the parties, all the evidence shows that's what the parties thought. They wanted the MF1 terms. What the judge found, bizarrely, was that actually somehow they'd reached an agreement that they would jettison all these terms they'd been carefully negotiating. And that just, again, it is not consistent within the document. Go back to the terms, my lords, just whipping through them. The clause 8 is obviously the nature of the services to be provided. It carefully prescribes, as one would expect, what the extent of the obligations are. And one can see, for example, in 8.2, the amended clause includes a provision that, in the red, that we're not going to be liable for breach of contract arising from any act or omission of a supplier of free issue equipment. So again, one sees instantly one's got the sort of protection that you would expect where someone else is providing equipment. One then has warranties that we've given, and again, very carefully identifying the extent of our obligation, particularly with regard to free issue equipment. We're not going to design, build and supply the free issue equipment. We're going to carry out integrations. The parties have been through a process of identifying the precise scope. Purchase obligations identified in clause 9, again extensive. Clause 10 and 11, at the heart of any contract, the payment regime. And in relation to clause 11, one sees that 11.2.1 and 11.2.2, a provision for payment of 30% of the contract price and then another 30%. 11.2.1 is one of the matters the judge picked up on as when he said the parties had not performed in accordance with these terms prior to the 29th of June. He said that we had not provided the advance payment guarantee. That's absolutely right, we didn't. Now, if one's doing a conventional analysis, all that would mean is that that wasn't regarded as essential. What is interesting is that they did pay us 30% during that period, and they paid us another 30% within 30 days of the delivery of the first line. So they began to implement the terms in accordance with the scheme that was identified here. One then has over the page at 1151, as again one would expect, detailed provisions under clause 13 relating to the passage and title and risk in the equipment, including again 13.2 and 13.3, risk in the free issue equipment that's coming to our premises. And so it goes on. And I don't, your Lordship will be familiar with the general scheme of these provisions.
General provision, beginning of clause 8.
That's right, my Lord.
The first 7 clauses on the first
That's right.
page.
So the MF1 terms are Schedule 1. That is the standard
They
MF1.
begin at clause 8.
That's right, my Lord. And your Lordships will be familiar with the again, standard in all of these standard forms, provisions for a programme to be agreed, delay damages to be given against a programme, a cap on delay damages agreed, provisions for extension of time in the event of a variation, provisions for extension of time in the event of a breach by the employer of his obligations, provisions to get extra money for variations, all of that contained within this clause, exactly what one would expect from a sophisticated client. One then has, if one goes forward, and sees on page 1155, liquidated damages in relation to delay, all agreed, caps are agreed. Then one gets to 27, 1158, which my learned friend was relying on. That sets out the obligation to do the performance tests. The nature of the tests is what's then set out in the schedules. So again, the modular approach. I'll come back, if I may, to 27.7 when I get to Schedule 6. Then one has, critically, 1158, Clause 36. Limitations of liability.
There's no reference to Schedule 7 in clause 27.1.
It's a mistake, isn't it? It should be 6.
Should be 6, maybe. So 27.1.
Clause 27.1.
Yes,
That's simply a mistake.
it should be.
It should be 6.
Yes, should be 6.
And it said 6 in the original.
Yes. As I said, this, and I apologise, there are type references because we did a delta view against each of them in order to compile this document and typed it in. So I'm not relying on it as absolutely accurate, just as more of an impression. Clause 36, 1158, again, negotiated clause. 36.1, the following provisions in this clause 36 set out the parties' entire financial liability, including any liability for the acts and omissions of their respective employees or agents to each other in respect of anything. In relation to 36.3, death or personal injury and fraud, there is unlimited liability. 36.5, save in relation to certain clauses, and I'll tell your Lordships what they are in a moment, the liability for all events of default shall not exceed what's specified in clause 5, which is the contract price, 1.6 million. And that was the point Lord Justice Waller was referring to in the Court of Appeal, that as it turns out on the facts of this case, the finding of a quantum merit solution we would submit doesn't actually make much difference, because we would have been limited in our liability to damages to 1.68 million. And if it's a quantum merit, the most they can get back is the full amount of what they paid us. So that we would be entitled to 1.68 million plus a variation, or it's reduced to reflect the value of the services. Now that wouldn't be true across every case, it just so happens that in this case it provides that solution. But that is what these appeals are about, and why my learned friends are so anxious to have these clauses out is because it avoids all of these limitations on liability, and their counterclaim, when it was last formulated and was ongoing, as an ongoing loss, was something like 5 times the value of the contract price. And as my Lord Clerk put in argument, that is what the debate is about. And my clients quite simply say, when this was agreed, no one in their right mind would have entered into an unlimited liability contract, which is what the judge has found, having spent all their time negotiating this, and still at the time the contract that is supposed to have come into existence, we found they're still negotiating and expecting to sign it, with the limitations in place. One then has, obviously, procedures for variations. The force majeure point, which Lord Ships
What
C.
difference would it make if one excised 27.7, assuming that was a theoretically possible solution?
My Lord, it doesn't make much difference. What happens, I'll show your Lordships what happens. It's badly drafted, and again, it may be a reason why one should allow contracts to actually be considered in the round before they're signed. It's 27.7.2. The amendments muddy the waters. Mr. Miller of Müller added in his passage in Schedule 6 to have some additional requirement. What he put in 27.7.2 is where the purchase has, and he put in not become entitled to liquidated damages due to the performance test not being successfully passed and the equipment not meeting the requisite standards to entitle the purchaser to claim the maximum liquidated damages, then they can terminate, which doesn't actually make sense. Yeah. And so one has a combination of, and your Lordships will see, an agreement, as the judge found, that the test plan sent under the email of the 29th of June would be Schedule 6. I'm sorry, Mr. Brown's email of 26th of May would be Schedule 5 and 6. That test plan does not refer to liquidated damages at all. So either Schedule 6 was replaced in its entirety, and what one ends up with, which again one sees in these contracts when one messes around with standard form wordings, is a conclusion that their only remedy is for liquidated damages for failing to pass, which is 0 because there are none specified in Schedule 6, or somehow the baseline agreement in the existing Schedule 6 lives with the new test plan, but it's still subject to the overall cap in Clause 5 of the form of agreement at 2.5%, which had always been agreed really right from the outset. I think it was one of the very first things that was agreed in January of 2005. And there was a variation up and down, but it had always been the position the performance tests would have that effect. And the reason was, under the standard form, if you didn't have that not inserted by Mr. Miller, what happened was you get liquidated damages up to a maximum, and then there was a right to terminate. And I don't think Mr. Miller fully understood that. And that was why he said it was an internal note to his people. He hadn't worked out that the actual standard form catered for what he was anticipating should occur.
You've got limited damages up to a point and then a right to terminate.
That under the standard form.
What, the purchaser?
Yes. So what one does is a performance test. In this case, it was a test with a formula that said within a 24-hour period you had to have 100% throughput on 95% availability. If you failed to meet that requirement, you paid 2.5% of the contract price on that one-off test. And that's your maximum exposure. If you then reach that maximum level of damages, then what should have happened under the standard form under 27.7.2 was that the purchaser then had an option to terminate because it was performing much below what was expected. And what Mr. Miller was, I think, in his evidence suggesting was that he was going to have some sort of graduated provision for liquidated damages, so there'd be at different levels between, 95% and 90% performance. Below 95% would be an option to terminate, for example.
I mean, his clause doesn't seem to make that point or make sense at all.
No,
the other thing which didn't struck me as not making sense is that 27.7.1 says contractor shall pay to the purchaser the sum set out in clause 5 within 14 days receipt, being a genuine pre-estimate of losses as a result of the equipment not meeting requisite standards. So one would expect to find in clause 5 a straightforward sum which was a genuine pre-estimate of losses. Query whether it would be a genuine pre-estimate since it would be a fixed sum. But in fact what you find in clause 5 is nothing of the sort. You say find percentage of contract price to be paid to be calculated in accordance with Schedule 6. Well, that's just a complete circle. And then it says maximum percentage of contract price for which liquidated damages payments paid is 2.5. So it doesn't tell you what the sum you use under Schedule 6 is.
It's because the original agreement was for the 2.5%. So what it originally...
Well, but I know now it's become, that's only the maximum, so you haven't got a sum.
Well, exactly. And that's what I was saying, that if the conclusion is these forms go in one conclusion, is that they have specified liquidated damages as the remedy for failing to meet the performance test, the answer is 0. because of the way it's drafted. And all I was submitting to Alois is one reason why these contracts do have subject contract provisions in, so you assemble everything and then look at it to see whether they make sense, because it's not uncommon, I'm sure your lordships have it, where you have schedules drafted by engineers, they don't actually mirror what the lawyers drafted. And what happened in this case is that Mr. Miller, who's a lawyer, drafted this, and the engineers were involved in drafting the schedules. As a matter of fact, that is what happened.
I mean, Schedule 6 you'll come to doesn't make sense at all as far as the capital section in capital.
And so we've set out in paragraphs, lordships have it in paragraphs 132 and 133 of our written case, what we say is agreed, if that helps. But the key point is that there are, this is a very detailed, agreed document covering every aspect of performance, which for some reason the judge says parties didn't intend to include in their contract. And one has to ask the question why. Sorry, Mr. Morris, I keep referring to Mr. Morris, the in-house counsel, as Mr. Miller, because I treat the two as synonymous for these purposes, I suppose. Your lordships have already seen on page 1161, clause 48. In my submission, it is, despite my learned friend's valiant attempts to treat it otherwise, has the effect of denying contractual effect to the whole contract until they're executed. Obviously, at some stage in the future, the parties could waive that, but that isn't the case that's been advanced by anyone. Your lordships also ought to note the definition, obviously, of contract is on 1162 in clause 49, which is what I suspect my learned friends and the judge missed. And then one has in 1163, bottom of 1162, the definition of engineer. Your lordships will recall one of the other things that the learned judge said the parties hadn't done during the period up to the 29th of June was for Müller to appoint an engineer. Well, that's again, with respect to him, a non-point, because as is common in these forms, there's a default provision. And the engineer is the person appointed by the purchaser to act as engineer for the purposes of the contract, or such replacement as may be notified by the purchaser to the contractor from time to time, in default of any appointment, the purchaser. So the purchaser is the engineer if they haven't appointed one, so it doesn't really go very far as a general point. And then force majeure event, my Lord Clerk was asking about the definition of force majeure, and that was the only thing that was agreed on these forms after the 29th of June. That was agreed on the 5th of July, and the amendment your lordship saw in those emails is identified in purple in the definition of force majeure event. But that is the only thing that was agreed after 29th of June.
Well, more importantly, it was the only thing that was outstanding that it wasn't agreed.
My Lord, I could not have put it better myself. So one then comes to the schedules, and we haven't included the documents. They are in your lordship's bundles. 1165. Schedule 2 was the one that did contain the contract price. And in the email from Mr. Brown of the 26th of May, he says, I assume we don't need a Schedule 2 because the contract prices will now be referred to in the main agreement. And that's why there is no Schedule 2 in there.
What main agreement?
Which is the form of agreement.
Was page 1147.
Is 1147, my Lord, yes.
1147 provides that the price will be in Schedule 2.
My Lord, yes, but then unfortunately, if one looks at 1162...
1148 is the price, isn't it?
1148 has...
Purchase of liability.
Well, that is the cap on liability, which is the equivalent to the price. But in 1162, contract price in the definitions is defined as 1,682,000. Look, my lords, and your lordships may want to look up. I'm sorry, I'm taking time with the facts, but it may help. If your lordships take from tab 51 onwards in Appendix 2. And then start at Schedule 3, the functional design specification. This is one of the documents that was sent through on the 29th of June.
Sorry, I'm a bit slow there. Which document are we on now?
Page 1165 in the MF1 form and page 888 in the Appendix 2, Part 2, behind tab 51. Your Lordship will see there's the 29th of June email from Mr. Guest of RTS to Mr. Morris.
I see these references are not to our bundle.
Yeah, well, that's what I said. We've kept them for the court as the Court of Appeal, and I apologise for that, but it was
Just to confuse the enemy.
just to confuse the enemy indeed.
So what's the
The Lordship's the enemy, I suppose. But 890 is the functional design specification.
890.
Yes. And so this is a document that the judge found, as we put in our note, the note that appears under Schedule 3 as our note, was found by the judge to be incorporated in the contract. And that was sent through on the 29th of June. On the Schedule 4 over the page is the user requirement specification. If your Lordships go back to tab 48, this is the email at 8:30 that I was referring to from Mr. Brown, where your Lordships will see that what he is introducing is our understanding of the current status of the contract schedules is as follows. So they are talking always, and I'll take your Lordship briefly through the earlier correspondence, always about contract schedules. So Schedule 2, we assume this is not now required. Schedule 3, this is currently being reissued following approval documents, suggests we refer to it, so if it's changed in the future, we don't need to reissue the whole contract document. Schedule 4, URS, it was agreed that Section 4 onwards of the RTS quotation would form the URS, and then it's attached. So for some reason, the judge is picking emails on the 26th of May and emails on the 29th of June, all of which are intended to be part of the contract, subject to the MF1 terms, as providing a separate contract. And nowhere is explained how he gets to that conclusion. And then turns to page 1167 is Schedule 5, and one keeps open page 830. 1170 is Schedule 6. And if one looks at, keeping a finger in those pages, page 830, under Mr. Brown's email, he says, Schedule 5, it was agreed that the RTS test plan would form this schedule. This is currently with Müller for approval. Upon approval, we suggest it's included in the schedule and existing test is deleted. Schedule 6, RTS test plan. And the test plan, your Lordship's already seen, was sent through on the 29th of June. And your Lordships have it at page 1044. And the judge found that is the document that forms part of the contract. It was what the friend relied on. And that leads into the discussion I had with my Lord Mance about what the effect is when one gets to page 1172 of my little bundle of the words that Mr. Miller had inserted. Because if your Lordships look at what Schedule 6 was saying, it says performance tests, which are now covered by this test plan. It had a formula on page 1171, 100% throughput, 95% availability. Fourth paragraph from the bottom, you can see it's a 24-hour test, and then repeats its 95% availability. The failure to meet that 95% availability criterion would have triggered liquidated damages at 2.5% of the contract value. And that is what maximum, but there was no other gradation.
But so it's a minimum and a maximum.
Minimum and a maximum. And what I think, as we understand it, what Mr. Miller was suggesting is that the required levels of LDs will effectively be graduated within a range, and then after that there'll be other remedies which would be termination, but they hadn't got to the drafting that. So one view is, certainly what the judge appears to have found, that based on Mr. Brown's email, the entirety of 5 and 6 are replaced with the test plan one has at 1044, which doesn't refer to liquidated damages at all. And so the remedy is 0 if they fail performance tests. Or you're left with the 2.5% for failure to pass the test as now specified. And what is provided as an additional requirement, as a matter of logic, if the contract is concluded, can't have been an essential term. So it comes back down to that debate. The 1173 Schedule 7, it's recorded as agreed, didn't form part of the contract as found by the judge, despite the fact it's agreed in the same email that the judge relies on as having other documents which are agreed, which do form part of the contract. Same point on page 1176, Schedule 8. (1179), one sees from the comment that this was to be completed.
Sorry, the point on Schedule 8.
Sorry, Schedule 8, I think Schedule 8 recorded, accurately recorded in Mr. Brown's email that it needed approval, but there was no further agreement reached in relation to it. So nothing happened in relation to the parent company guarantee. 1179, Schedule 9. Mr. Brown's email, again, which the judge relied on as showing approval of some matters, was to be completed during the project. The judge found that Part 1 was never completed, but Part 2 was. But I don't believe that it actually forms part of the contract that he found. No, it doesn't. And Part 2 on page 1180 again has a maximum percentage, and presumably he didn't allow this because it would have referred back to the MF1 forms immediately. But again, it's capping our liability for maintenance and repairs. 1181, the programme, the judge has found that it was overtaken by the overall project programme, which was sent under cover of the email of the 29th of June, which your lordships have at tab 51, page 888. And the build and test plan was sent on the same day and would fall into the same category, and your lordships have that at tab 52, 1102. The 1182, again, we're back to Mr. Brown's email, picking some parts of it and not others, recorded as part of the contract schedules in the email of the 26th of May, but found by the judge to have been agreed and form part of the contract that he found. It's tab 48, page 830. 1183 is an example of something that wasn't completed, but that was because it was to be done by Müller. Similarly, on 1187, the judge relied on Mr. Brown's email again, this time to say that this could never have been completed at the outset of the contract. If one gets to 1189, Schedule 15, again Mr. Brown's email records that Müller were to provide the details, but no agreement was recorded. And this is another example of, in paragraph 75 of the judgment, the judge relied on the fact that this had not been agreed as being a basis for saying that there hadn't been performance in accordance, or that the terms of the contract had not been agreed. So if one takes the judgment to tab 4, page 58, so it says, RTS did not procure the provision of the advance payment guarantee. Well, I've shown the lordships that that relates to one small part of the sentence in one clause of F1. Schedules 15 and 17, which address matters relevant from the start of the contract, are not completed. So this is one of the reasons why he says there wasn't an agreement. But this is something that Müller ought to have done. And having just held correctly in paragraph 74 that the agreement was intended to operate as a composite whole consisting of the basic 2-page 7-clause contract and 17 schedules, the logic would appear to be that if this hadn't been agreed, then none of it had been agreed. Because if it's a composite contract and it must fall because part of it hasn't been agreed, the whole lot falls. And that's part of the problem with the judge's reasoning. At each, and I'll go through each of those headings. I can do it briefly now. One, I will go through the evidence. All of the evidence he relies on, quite rightly, shows that the parties expected the whole contract to be signed. And that culminates in the 5th of July letter, but that's the whole contract. So it's an all or nothing point. It either is the whole contract or it's not. It's a composite whole, that is all of the schedules that Malone Friend relies on. So if it's a composite whole, it is a composite whole. If part of it can't be enforced, the whole goes.
Actually, I wonder if I could just ask you this before we stop. One, would it be very inconvenient to ask somebody on your side to provide on a piece of paper the cross-reference to the documents, the references you've got in your black file?
I will say.
And the second point is that where would we see what order you're asking the court to make on the hypothesis that there is a contract?
On the hypothesis in the contract, it's paragraphs 132 and 133 of the case set out what we say were agreed.
Yeah.
What order are you asking?
My Lord, if your Lordship wants an order
Well,
incorporated.
just a draft,
Yes.
like to see.
My Lord.
Yeah, we'll adjourn until tomorrow.